Hello and welcome to Freebie Friday on NLF Live. And today I'm going to be talking about whether or not you can drop charges against somebody. So we get a lot of calls from victims of domestic violence specifically, asking whether they can drop the charges against the alleged abuser or the perpetrator of the act of domestic violence. And so what we'll hear is, oh yeah, well, I told the police that I want to drop the charges, or I told the district attorney that I want to drop the charges, and they haven't. And that's because it is not the victim or complaining witness's right to drop charges. If a report has been made, the police will do their investigation and arrest somebody, then that report is forwarded to the district attorney's office, and the district attorney will look at it and make a determination as to whether or not charges should be filed. Is there sufficient information included in this initial report for them to make a complaint and file charges against the suspect? So once that happens, the case is titled "The People of the State of California versus John Doe." It's not the victim's name versus John Doe. So that victim or complaining witness does not have the right to dismiss the case. It's not their case. It's California's case, or that particular county. So the district attorney, even if you call them, they might take into consideration your feelings in terms of how they are going to make an offer, and they'll probably note whether or not you're cooperative, but that is not going to convince them or force them into getting rid of the case. Some of the things that we see happen typically are the complaining witness will show up to court, and sometimes we will help facilitate them in speaking to the district attorney or the judge and saying that they don't want a criminal protective order in place so that the parties can reunify and be back together during this process. But and the fact that the complaining witness is cooperative or has changed their story may go into how we proceed with the trial or how we negotiate the case. But it is not a guaranteed dismissal just because somebody has changed their story or just because they want to take back the fact that they called the police. So that's just a quick rundown on what rights does the complaining witness or victim have in dropping a case. There are a great deal of different rights that are given to victims in the state of California, like they have the right not to cooperate with defense attorneys or cooperate with anybody that's acting on the defendant's behalf. And they also have the right to not be punished if they refuse to testify. But if they're given a subpoena, they do have to show up to court, but they can't be punished with jail for refusing to testify. There are other things that can happen to them, like fines and other things that can be put into place, but going to jail isn't one of them, as long as they show up and the refusal takes place there. So there are some nuances to what the victim's rights are and, who they're cooperating with and which rights they want to enforce. But most importantly is, unfortunately for us, a victim that calls and wants to just drop the case, there's nothing we can really do about that except for referring them to outside counsel or to speak to an investigator. Okay, well, until next time, have a great one. Bye.